Hello, my name is Scott Schwartz. I'm a senior counsel with the law firm of Clyde & Co. US LLP. This video will provide a quick review on contractual limitations provisions in fidelity bonds, including how they work, why they are important, and when they are enforceable. So what is a contractual limitations provision? Well, all jurisdictions in the United States have statutes of limitations that apply to claims for coverage under insurance policies. Standard fidelity bonds and commercial crime policies typically have additional provisions that create a contractual limitation on when an insured can bring an action against the insurer for coverage under the policy. These often create what is called a contractual limitations period for an insured to bring such an action that is shorter than the applicable limitations period prescribed by statute. Up on the screen here, we have two examples of provisions setting a contractual limitations period in fidelity bonds and commercial crime policies. Not surprisingly, those states considering the validity of such provisions have reacted differently. Some states have upheld the parties' rights to freely contract to shorten contractual limitations periods, while others have been reluctant to enforce such provisions on the basis that statutes of limitations are representative of public policy and therefore may not be shortened by the parties. So why are these kinds of provisions so common and important in fidelity bonds? What's their purpose? Contractual limitations provisions are intended to promote the quick resolution of claims before they become stale. The insurer's timely receipt of information is particularly important in the investigation of claims regarding fraud and theft, as evidence of dishonesty can disappear or be concealed by those committing the misconduct over time. The contractual limitations period provides incentive to all parties to come to a position on the claim before evidence has disappeared and witnesses for the claim become difficult to locate or their memories fade. Where state statutes of limitations would allow too much time to pass for efficient adjudication of claims under fidelity bonds, the contractual limitations period is intended to ensure the claims are brought sooner. You will note that the contractual limitations provision also prevents a lawsuit from being brought too soon after the insured first discovers its loss. This way, the insurer will have adequate time to finish its investigation prior to the commencement of any lawsuit. The enforceability of contractual limitations periods varies greatly from state to state, and choice of law, therefore, may be an important threshold issue to determine whether an action is timely brought. The majority of states allow insurers to include reasonable contractual limitations periods, even if they are shorter than the statutory period. Other states, however, do not allow insurers to enforce contractual limitations periods at all. Courts in those states reason that the statute of limitations represents a legislature's determination that a plaintiff should have a certain length of time to bring suit for different kinds of actions. On that basis, those cases have found that private parties cannot eliminate a plaintiff's right to bring suit prior to the statutorily prescribed time. In many states, the enforceability of contractual limitations periods is governed by a statute. Some states have statutes that specifically render only some contractual limitations periods in fidelity bonds and other insurance policies unenforceable. For example, some states have statutes that require all contractual limitations periods in insurance policies to be at least 2 years. Many states enforce contractual limitations periods if they are shorter than the applicable statute of limitations, but do not allow the contractual limitations period to be longer than the applicable statutory limitations period. For example, if the statutory limitations period is 2 years, it will not be superseded by a 3-year contractual limitations period. The 2-year statutory period will still be the period that's enforced. This seems counterintuitive at first, as parties can often toll statutes of limitations. But this quote on the screen from the New Hampshire Supreme Court explains it well. Parties cannot agree in advance that statutes of limitations will not apply to their contracts. An almost universal rule across the states is that any contractual limitations period has to be reasonable. This requirement is usually not based solely on the length of the period. Rather, courts have ruled that contractual limitations periods are unreasonable when they ultimately prevent coverage under the policy at all. For example, in Executive Plaza LLC versus Peerless Insurance Company, the New York Court of Appeals noted a contractual limitations period that required suit to be brought before an insured could complete other conditions precedent to coverage was unreasonable and therefore invalid and unenforceable. There are various defenses that are sometimes raised in response to contractual limitations periods we wanted to briefly address. One important question is the date that the period begins to run. Depending on the specific language of the bond, the limitations period may run from the date of denial of coverage rather than the date of discovery of the loss. Similarly, some states will equitably toll contractual limitations periods during the insurer's investigation. It's important to be aware of the state's rules regarding interpretation of the language of the bond for the contractual limitations periods to determine the date the period will begin to run from. Claimants often raise waiver and estoppel to contractual limitations period defenses. Waiver is generally defined as the voluntary and intentional relinquishment of a known right. Estoppel is generally defined as where the insurer lulled the insured into sleeping on its rights under the insurance contract. Both of these defenses are very commonly raised by claimants, but courts will often not apply them without a specific reason. Importantly, courts have ruled that insurers cannot be found to have waived or be estopped from enforcing the contractual limitations provision by simply investigating the claim. Additionally, based on specific language of the bond, the limitations period may only apply to contract actions and not related torts. Finally, a small minority of states require an insurer to show prejudice in order to deny coverage for breach of a contractual limitations period. Most states, however, equate the violation of the contractual limitations provision to violation of a statute of limitations, which does not require prejudice to defeat coverage. We hope you found this brief discussion of contractual limitations provisions in Fidelity bonds helpful, and thank you for watching.